afternoon, everyone. Let me try to share my screen. You can see my PowerPoint, right? Yes? Okay, good afternoon. Now, the law of unjust enrichment in Hong Kong is still largely in its infancy. Now, despite the historical recognition of unjust enrichment dating back to 1985, the development of this branch of law has unfortunately been sluggish in Hong Kong, perhaps due to the relatively recent recognition of the modern law of unjust enrichment in England after Lipton, Gorman, and Carpnail. Few parties opt to plead unjust enrichment as a separate cause of action in Hong Kong. Mostly, they still rely on the more traditional claims that lie in contract, equity, or property law. So the existence of jurisprudence in Hong Kong on unjust enrichment has largely cited and followed the English position. So most of what I say will echo what you have just heard from Professor Tang. So in line with Hong Kong's rich history of English common law tradition as a former English colony. However, there exists some interesting divergences from the English position in a few specific areas, which I intend to focus on, especially in the defenses. The two that we'll talk about is the change of position and the illegality defense. So some of this jurisprudential divergence is unfortunately problematic. So based on an unprincipled misunderstanding, I would say, of previous English decisions, which may lead to undesirable outcomes. So this is the overview of what I want to talk about. So basically, talk about how Hong Kong courts have adopted the English position, and of course, emphasizing where it differs. Okay, so the law of unjust enrichment, it exists as a distinct cause of action in Hong Kong that is subsidiary in nature, just like Singapore. So the first successful case of unjust enrichment in Hong Kong that I could find dates back to 1985 in Professional Associates in Polytech Engineering Company Limited in the High Court. So it was officially recognized unjust enrichment as a distinct cause of action from contract. This case concerned a claim by the plaintiff firm of architects for the value of their services in helping the defendants build a hotel that was ultimately abandoned. The plaintiff's primary claim was a breach of an oral contract, alternatively, in restitution on quantum merit basis. So that's the way it was pleaded. In allowing the plaintiff's claim on both grounds, Deputy High Court Judge Prudent held, so I want to read the paragraph here to you, restitution is a generic term for a relatively new course of action which has evolved markedly during the past 20 years. Although its history, it diffused under a variety of differently named remedies, going back very much further. Quantum merit is merely one species of restitution. The juridical basis of restitution is quite distinct from contract, although quasi-contract is one species of restitution. For a time, attempts were made to rationalize restitution on a contractual basis by reference to implied terms and other fictional devices. Fortunately, the better view that restitution is found on the doctrine of unjust enrichment rather than implied contract is now firmly established. So we have this case in Hong Kong even before Lipton, Gorman, and Carpnail. Court allowed the plaintiff's claim for restitution. The subsidiary nature, again, just like Singapore, was further confirmed by the Hong Kong courts in Great West Industrial Limited and Sun Fook Kong Construction Limited. The case concerned a claim by a subcontractor against the main contractor of a construction project for the Hong Kong Housing Authority that was ultimately not completed. The Court of Appeal held that a subcontract between the parties precluded the claim in unjust enrichment, since the enrichment pursuant to a subcontract would not be unjust. So in this subsidiary role, Where a contract still subsists, then the court will not allow a claim in unjust enrichment. Therefore, in this respect, law on unjust enrichment in Hong Kong largely mirrors that in England. Unjust enrichment has a separate existence as a distinct cause of action. However, it is still subsidiary or residual in nature. Although this point itself is academically contested, the secondary nature of unjust enrichment claims remains the law in both England and Hong Kong. And now for forming the cause of action. Now, the elements, or maybe I should call it elements, I should call them the analytical framework for an unjust enrichment claim in Hong Kong, again, largely mirror those in England. The Court of Final Appeal in Shanghai Tongji Science and Technology Industrial Company Limited cited the Banque Financière case in England and adopted this four-question approach. So firstly, was the defendant enriched? Was the enrichment at the plaintiff's expense? Was the enrichment unjust? And are there any of the offences applicable? Some academics would even argue that there's a fifth question to answer, that is, what is the appropriate response? I.e., should there be proprietary restitution? Does it even exist? Now, of course, this issue has not arisen in Hong Kong. So that's why, at least for now, there are only four questions. And what needs to be considered is this four-stage framework is not meant to be a legal test. They are only meant to be useful questions for the court to ask. So you can see warnings by the UK Supreme Court in Bank of Cyprus and Manilau gave a warning that the four stages do not have statutory force and are merely aimed to ensure a principled analysis of the unjust enrichment question. In the next case, investment trust companies, Lord Reed also further held that there are no more than broad headings for ease of exposition. They are intended to ensure a structured approach, but they are not themselves legal tests. So from looking over the Hong Kong cases, fortunately, Hong Kong courts have generally been careful in framing the approach as a useful framework. So they call it a useful framework or relevant questions rather than strict legal tests. So they have not, even the lower courts, district courts, have not fallen foul of the warning in ITC. So this four-stage framework therefore governs the determination of unjust enrichment claims in Hong Kong, as with the position in England. Now, when we get to the enrichment question, we come to some more Hong Kong cases. Again, the principle largely follows the English authorities in Manila. So we have Mui So Bing, not Manila, excuse me, it's Benedetti and Sawiris. This case firstly cited Sawiris and affirmed that enrichment is valued at the time of receipt, whereas subsequent profits are irrelevant. This case, unfortunately, does not say anything about whether this valuation exercise is subjective or objective. All I could find is a district court decision which has an operative statement that says enrichment is objective financial value. Now, no case in Hong Kong I could find has any discussion on subjective valuation or overvaluation like Benedetti and Sawiris, mainly because, again, from the cases that I could find, majority of the Hong Kong cases are only about valuation of money. And nobody so far has argued that money has no value or lesser value than the objective value. Even though there are a small handful of cases on services, valuation of services, those did not involve a contest over valuation. So they were agreed. So that's the position of enrichment. And then at the expense of, that's more interesting because there's a little arguably divergence from England. Is there a direct transfer rule? Generally, yes. But then Hong Kong courts, so Lee Yuk-shing and Dianor, they tend to adopt the wording from Manilau that says it's not so strict to have a direct transfer rule, but what you need is sufficient causal connection, such, or in other words, sufficient nexus or link. The facts of Dianor is very interesting. It concerned an unjust enrichment claim against the defendant seller of rough diamond stones. The plaintiff's payment for diamond stones was carried out by his uncle. So the defendant did not directly receive the payment from the plaintiff, but received it from the plaintiff's uncle. So in other words, there's no direct transfer. Nonetheless, the Court of Appeal found that the close relationship between the plaintiff, his uncle, and their company, as evidenced by the sharing of their funds in a family pot, satisfied this so-called causal connection requirement, despite the lack of a direct transfer from the plaintiff to the defendant. And then we come to the next, the newer Hong Kong case, one from this year, District Court, Jensen Power Systems and Li Shan Shi. This case built on the UK case of investment trust companies. But what I find problematic in this approach is this case is mixing up the sufficient causal connection, the looser approach that we get from Manilau, with the stricter approach with investment trust companies. So if you read Jensen, the court starts by saying there's no strict requirement of direct transfer. All we need is a causal inquiry in determining whether a defendant has been enriched at a claimant's expense. And then the court goes on to summarize the 5 famous examples given by the Supreme Court in investment trust companies. So where there is an agency relationship, where there's an assignment of a right of restitution, where an intervening transaction is found to be a sham, or where a set of coordinated transactions being treated as forming one single transaction, or where the defendant receives property from a third party into which the claimant can trace an interest. So these are all examples of where, on its face, there's no direct transfer, but which would satisfy the causal connection test. Now, what I find problematic from this is if one carefully reads investment trust companies, the Supreme Court in that case was not too content with the vague and generalized language of sufficient causal connection or sufficient nexus or link used by Manilau. So what I can see is the 5 illustrative scenarios that I've just set out, they are arguably tighter situations and not so loose as a causal connection, where the difference, in the words of the Supreme Court, the difference between direct and indirect provision of benefit is more apparent than real. So this current expansive position that we can see in Dianor and Jensen, again, also runs contrary to previous decisions, such as CUHK Foundation Group Limited, where the court of first instance struck out a claim on unjust enrichment against a company's sole shareholder for sum paid to the company. So in CUHK Foundation, the court held, even though it is a single shareholder company, they are not to be treated as a single entity for the purpose of at the expense of oppression. So this judicial position seems to be, to me, inconsistent with subsequent decisions and analyzed above, and the looser causal connection requirement seems to be satisfied on these facts. It would likely have to be revised due to the loosened direct transfer requirement that investment trust companies. One should note, however, that Jensen is a district court level case decided on paper only, and the defendant was without legal representation, perhaps due to a lack of corresponding factual circumstances. The issue of incidental benefits also was not discussed, even though it was expressly discussed in Manila. Let me move on now to mistake. So interesting point observation I have is on a review of the cases for the past 5 years in Hong Kong, suggests that mistake is by far the most frequently relied upon unjust factor in unjust enrichment claims in Hong Kong. And they're all about unraveling fraud, email or identity fraud. I can see that Hong Kong case, well, the one that I could find is unfortunately only at district court level, which generally adopts the English position. Well, seeing that I have only 5 minutes left, I want to jump to the most interesting part, in my opinion, which is defenses. So generally, the Hong Kong courts follows the English position in Lipton, Gorman, and Carpenter in saying that there is a defense of change of position. Right? So stopping this is available to a person whose position has so changed that it would be inequitable in all circumstances to require him to make restitution, or alternatively to make restitution in full. Now, in the next passage, my reading is that there are two distinct exceptions to this defense. So the first one is the defense is not open to one who has changed his position in bad faith. My reading is this is distinct from the next, the yellow part. It is commonly accepted that the defense should not be open to a wrongdoer. So I suggest that from Lipton, Gorman, and Carpenter, there are distinct defenses of bad faith and wrongdoer. But then Hong Kong courts, of two particular cases, I think, has mixed up the two. So the first one is Arrow ECS and Am Yang Limited. This case concerned a summary judgment claim by the defrauded plaintiff against various currency exchange operators who had received the defrauded sums. The defendants relied, of course, the defendants would say they have no connection with the fraudsters. So all they would rely is the defense that they had received and subsequently paid out funds in good faith and in the usual course of their money changing business. However, the court first instance rejected the defense because it was not in compliance with any anti-money laundering and counterterrorism financing ordinance in Hong Kong. So what did the court held? The court held that the defense cannot be relied upon because they did not act in good faith. So the general English position is good faith or bad faith doesn't need to be dishonesty. It could be failing to act in a commercially acceptable way and sharp practice. But the court here held that in view of the illegality mentioned above, I found that the defendants failed to act in a commercially acceptable way. So the first problem I could identify is the UK position in Juliet Bellis' case that this bad faith has to be committed vis-a-vis the plaintiff. So it's not just any illegality. It must be something you owe a duty to the plaintiff and you do it. But in Arrow, this arguably this illegality is only some legislation unconnected with the plaintiff. But the court nevertheless held that this was sufficient to defeat the defense. 1 minute left. The second problem I see is a wrongdoer exception. Again, this one, the English position is it doesn't need to be against the plaintiff, but in Jeremy D. Stone, this illegality needs to be something sufficiently grave, right? So, but in the Hong Kong case, DBS Bank and Panjing, the court held that even breach of PRC foreign exchange law, so arguably regulatory offenses which are very minor. These are sufficient for the defense to be defeated. So again, I think this is not a good development. It inhibits the change of position defense from supporting the expansion of unjust enrichment, because this is the intention of Lord Gough when he first talked about this defense, in that even though the claim is strict, but we need defense, good defense, to ensure its good development. I think my time is up. Thank you for your time.
Well, thank you very much, Arthur, for that very detailed presentation.